So as mentioned again by the two speakers earlier, information can be used to convict the guilty, to prove that somebody is guilty, or to exclude and exonerate the innocent. The data is very powerful. DNA data is very powerful. It's not always to catch criminals. On the other hand, it's like a sword with two edges. It can be used to prove innocence of a person. So when you look at the Identification Act, I think this act is a very important act or a bill. We should have a look at it. When I look through it, I have many questions. So I share with you my own questions. Are we clear with respect to the purpose, scope, and function of the proposed DNA data bank? In the bill mentioned, in fact, it's not very clear. What is the scope? What is the purpose? What's the function? Are we? And then, if you look at the act, they can, as mentioned by the first speaker, there are 7 categories of people, from even drugs, drug user to suspect or detainees. Are we satisfied with the 7 classes of indices listed in the act? So there are 7 classes, and therefore each one is an index. There are 7 indices. If you compare our Malaysian bill, this particular bill, with many other bills, we are not the, please bear in mind, we are not the first country drafting this bill. So in a way, the question is, do we need to reinvent the wheel when there's already a wheel? Okay, the first act was drafted 10 years ago, more than 10 years ago, 1995 in Britain. And since then, there have been many other bills in the country. And if you compare this particular bill with other bills, in fact, I don't remember seeing many that have classified 7 indexes, a lot. I don't know, maybe it's Malaysia Boleh or unique situation. So, then, as mentioned in the Act, the power given mainly to the head. At the head, are we concerned with the stated qualifications, functions, and power of the head of DNA bank, data bank, and also the deputy head and other officers? There are listed categories in the bill. Who are the ones? And all are pointed to one category of people, which are the police. The police will be the head, appointed from the police, deputy head also from the police, and so on. Okay. Then we need to ask: are they proficient? Are they competent? To do all these jobs? Next, please. So, can the head of DNA bank be empowered as the competent custodian? That person is the custodian who maintains the integrity, accuracy, and security of the DNA bank, because everything is in the electronic database. And as you know, electronic database can be hacked. If it's not done properly, the whole information can be wiped off very quickly as well. And if it's not properly, again, it can be mismatched as well. So there is possibility. Human errors is always there. Now, is the head of the DNA bank advised? It's not clear again in the bill. That everything is head. The head reports to the minister, but it's not stated whether the head of department or the head of the bank is advised by individuals or a board. If you want to put a police, fair enough. If the person is not competent, then in many other countries they have, on top of that, there is a board of competent either scientists or NGOs, people who are involved. They can give advice, or they can have help the head. The head has to report, and then they go through the process. So here it's not clear. Is the head advised by individuals or a board? Again, the next thing is who monitors the proficiency and competence of the head and deputy head of the DNA database bank. As mentioned by the second speaker, the information that based on this act, the DNA evidence is very, very powerful. In the court, it's the conclusive evidence. In other words, you can send someone to death based on that evidence. And the head monitors, so who checks on the proficiency of that? And then the other thing is, will individuals whose DNA data are listed in the data bank be codified to protect their identities? We don't know the detail. In many countries, again, you may give your name, but your name will never appear because it's coming in code. So that even if this information is leaked, nobody knows that this is your DNA because it's in code. Yet another person holds the key to the code. So there are sort of check and balances. And as mentioned by the first speaker, whatever law we have, we should, and also the second speaker, we should check this law. This law should harmonize. I'm not a lawyer, but still I should realize that there are already existing laws which cover these things. So we should ask ourselves whether this particular law harmonizes with other existing law. In other words, do they clash with each other or not? Or are there sufficient legal framework to protect us? So by rights, actually, there should be a Personal Data Protection Act. In many countries, they have already a Personal Data Protection Act. It means to protect the confidence, the confidentiality of the data. And now we don't have this particular act. And also the Human Rights Act. Like it or not, everything involved is related to human rights as well. So we have to ask all these questions. So the other thing is that we must set DNA evidence is very powerful. If not handled professionally and properly, can be misinterpreted and lead to miscarriages of justice. And that's the worst miscarriage, in that where a guilty person is exonerated and an innocent person is wrongly convicted. It's the other way around. It should be, the guilty should be convicted, not exonerated. Okay. And furthermore, there is possibility that biological samples are contaminated, are tampered with. They are highly mobile. DNA samples. Once you get a DNA sample or even the biological samples, they are highly mobile. In other words, I can get your hair, I can get your blood sample, I can leave them at various spots. And this has happened before in other cases, implanted, switched and planted where they ought not to be located. So there is a lot of trust when somebody holds on to that kind of material. Okay? Now, in view of these acts, or the facts, can we accept Section 24 of the Act, which states that the information from the DNA data bank to be conclusive? So this is a very, very scary statement, that it is conclusive. There should be provision that before anyone is convicted of DNA evidence, there ought to be corroborating evidence. DNA evidence itself is not sufficient. This is worldwide. In fact, DNA is very powerful, but it's never been the only one and only evidence to use for judgment. It actually has to be corroborative. What about requests for appeal and post-conviction DNA testing? Okay, in many countries, again, you can appeal. If the evidence proves that you were guilty, but you are very sure that you are not, that there's been something wrong with the testing, you can appeal. And then there are processes whereby the person can use them for what is called post-conviction, can have a third party to carry out the trial or re-look at the whole data. Does the Act adequately cover the activities of collecting, recording, storing, delivering, preserving, retaining, typing, and destroying biological material? As I mentioned, you involve all these things. It must be spelled out. Who has the right to retain it? It doesn't mean that once it's in there, it will never come out. It's always there. Please go back one.